Thank you very much for your nice word. Thank you for coming. So this will be a short demonstration lecture. You know already the title, Law as if Earth really mattered. What if ecocide were a punishable crime? The topic in itself is not really funny, but still there's some hope, as we will see. So this is precisely the question I would like to address with you today. As a broad generalization, ecocide is defined first and foremost by the destruction, degradation of ecosystems and specific environments with harmful consequences for the living creatures to which they are home. Currently, there is no international law to stop ecocide. As we will see, there are just a few national laws which address this issue, but at the international level, basically, there is no international law addressing ecocide. Of course, we have many international agreements focusing on environmental issues. We have conventions, protocols, treaties, declarations, and so forth. But none of these actually prohibits the large-scale impairment of ecosystems. Existing international laws, in fact, do not impose an international legal requirement to uphold nation-state and corporate responsibility for ecocide. And yet, ecosystem damage, destruction, or even loss is occurring every day, from floating plastic island to mountain top removal and deep sea mining. The worldwide destruction of ecosystems is worse now than at any other time. So let's remember, for example, disasters such as the Deep Horizon oil spill in 2010, or let's consider the ongoing deforestation and toxic dumping in the Amazon, or the development of what we call large-scale fracking. In different parts of the world, actually a growing number then are trying to react. A growing number of lawyers and environmental advocates recognize that our current environmental regulations are far too weak to prevent, to stop, or to redress cases of massive environmental degradation. And in order to better protect then the integrity and functioning of ecosystems, they suggest to make ecocide an international crime. They think that prohibiting ecocide and creating a law that makes it mandatory for states and corporations to end ecological ecocide and significantly abate climate ecocide has the potential to be a game changer on a global scale. Such a proposal, interestingly, is gaining widespread international support from environmental advocates and specialized lawyers, as I just mentioned, to politicians, academics, and the public at large. So today I would like to examine with you this kind of roadmap to Earth protection and climate justice. So this proposal to make ecocide an international crime actually is taking place in a specific context. There's a first trend, among many others, the development, fast global spread of what we call environmental courts and tribunals, meaning specializing in environmental cases. And this fast global spread of such courts and tribunals is considered as one of the most dramatic changes in environmental law and institutions in the 21st century. In the 70s, only a small number of these specialized courts and tribunals existed primarily in Europe. In 2009, when the first global study of these courts and tribunals was done, more than 300 of these courts and tribunals could be actually documented, and today we have more than 1,000 environmental courts and tribunals in at least 44 countries. This continuing increase is being driven by the development of new international and national environmental laws and principles, and also by the recognition of the linkage between human rights and environmental protection. But there is actually a second trend, what we call climate change litigation. Today, in fact, the judiciary is increasingly exposed to climate change arguments in cases where, until recently, the environmental argument would not have been framed in those terms. And indeed, litigation has arguably never been a more important tool to push policymakers and market participants, big corporations included, to implement effective means of climate change mitigation and adaptation. So far, climate change cases have been filed in 24 countries, with a majority of these cases filed in the US, and over 270 cases filed in other countries combined. So just to give you a rough idea about this kind of climate change cases, we have a quite famous case called Urgenda Foundation versus the state of the Netherlands. Urgenda Foundation, which is specializing in environmental protection, and a group of no less than 900 Dutch citizens decided to sue the Dutch government in order to compel the state to reduce greenhouse gas emissions, primarily CO2, more aggressively. And very interestingly, in this case, according to the decision adopted by the court, the Dutch government was recognized as obligated to reduce its greenhouse gas emissions by at least 25% by 2020. And this in order to fulfill its duty of care to protect Dutch citizens against the imminent danger caused by climate change. So here we have basically a court which underlines the necessity for a government to be more ambitious in the design of its environmental policy and climate change policy. But there are so many cases, and just another example maybe, called Native Village Kivalina versus ExxonMobil Corp. Kivalina is a small island north of the Arctic Circle, and it is threatened by rising sea levels due to climate change. It's estimated the island will be completely submerged by 2025, and at present the Kivalina's inhabitants lack the resource to relocate. So the complaint was filed in February 28 by the governing bodies of Kivalina, and then the inhabitants asserted in this case that no less than 24 oil, energy, and utility companies named as defendants in this case, means some of the biggest greenhouse gas producers and emitters in the US, ExxonMobil, Chevron, BP, Peabody, and so forth, should be held liable for the costs of relocating the village, estimated at $400 million, because they had allegedly contributed to the risks of climate change through their greenhouse gas emissions. Their claim, however, was finally dismissed. It's a long story, but this reflects the limitations of climate change litigation, and in fact, due to a number of obstacles, the prospects of a successful lawsuits for climate change-related damages remain mixed. So considering these limitations, a number of lawyers and environmental advocates have been suggesting to go a step further by making ecocide a crime. This proposal is currently being pushed forward by two international campaigns, Eradicating Ecocide and Ecocide on Earth. And these campaigns basically highlight the need for legally binding mechanisms in both national and international law to hold perpetrators of environmental harm accountable for the extensive damage to destruction or loss of ecosystems. Interestingly, this idea of making ecocide an international and a national crime is drawing from a conceptual framework, from new ideas, new approaches, new critical approaches to law, to both environmental law and criminal law. So we have a first theoretical background called Earth Jurisprudence and Wild Law, which informs the development of this idea of making ecocide a crime. These proposals to unrelated campaigns draws on these ideas, and Earth Jurisprudence basically refers to a holistic approach to law and governance, and more precisely, it is a legal philosophy that advocates a re-examination of the value system underpinning most of our legal and governance systems. This philosophy proposes a radical shift in these values so that legal and governance systems can support, rather than undermine, the integrity of the earth. So very quickly said, in this view, nature is recognized for its own inherent value, and not only for its many benefits to humans. In other words, nature ceases to be a collection of objects for human use and is regarded instead as a wider community of beings. So from this perspective, human societies will only be viable and flourish if they regulate themselves as part of this wider Earth community. Wild law, what we call wild law for its part, is formal law based on principles of Earth jurisprudence, and as such, wild law has a number of characteristics. So I will go quite quickly just to mention about the fact that in the view of wild law, in the view of the proponents of wild law, the whole natural world is regarded as a commons, which cannot be reduced to private ownership. This attitude has significant implications for property law because it questions the nature and extent of human rights over land. What we call human rights over land, such as ownership, for example, are seen by Earth jurisprudence and wild law proponents not so much as rights, but rather as special privileges which necessarily carry a number of obligations. So to sum up, wild law puts the Earth's well-being at the heart of all decision-making processes, or seeks to do so. And importantly, Earth jurisprudence and wild law have been recognized already at both the domestic and international levels. For example, we have a number of jurisdictions in South America, more particularly, not exclusively, which have already recognized such principles in their own national laws, including at the level of constitutional laws. And we have also a range of international declarations explicitly recognizing such principles. But there is another range of critical ideas which informs this idea of making ecocide a crime. And it's a range of critical approaches to criminology. So the word is a bit scaring, but we call it, this critical approach is called eco-global criminology. And in fact, the proposal of making ecocide a criminal offense assumes that transnational environmental harm is a crime. And in that sense, it draws on eco-global criminology. So basically, for eco-global criminologists, the first question to ask is what harm is there in a particular activity, rather than whether the activity is legal or not. So in traditional criminological conceptions, it is breaking the law that is a key issue. But for critical green criminologists, actually, and by contrast, the argument is that we need to expand our notions of what actually constitutes an environmental crime. So in this view, harm demands more encompassing definitions than that actually offered by conventional law and a mainstream ecology. This is because some of the most ecologically destructive activities, such as clear felling of old-growth forests, for example, are quite legal. Hence, the need, according to this view, the need to redefine environmental harm by incorporating ecological conceptions of harm regardless of legality per se. So a possible way of making ecocide an international crime, once we have drawn from these conceptual approaches, one possible legal and concrete way of making ecocide an international crime is to introduce it under the jurisdiction of the International Criminal Court, the ICC. So the ICC is based in the Netherlands. It is governed by the so-called Rome Statute, which was adopted in 1998 and entered into force in 2022. So the ICC is the first permanent international court established to prosecute individuals for the most serious crimes of concern to the international community as a whole. The Rome Statute, possibly the most important international legal document we have, states that the ICC has jurisdiction over 4 crimes against peace, as long as they have been committed after the 1st July of 22, namely genocide, crimes against humanity, war crimes, and a crime of aggression. The ICC is designed to complement existing national judicial systems, means it investigates and prosecutes such crimes only when the relevant national courts are unable or unwilling to do so. So it's very respectful of the national sovereignty in that sense. A case can be raised concretely by the ICC in any one of 4 ways: by the United Nations, means the United Nations Security Council, by a state party of the ICC, by a prosecutor of the ICC, and very importantly, even if it's very difficult in practice, by an individual or an organization, for example, a human rights organization, submitting to the prosecutor information on crimes within the jurisdiction of the ICC. So individuals can raise private prosecutions, and where the state fails to act, then the ICC can step in. Importantly, the ICC has the power to hold individuals accountable, which includes not only heads of a state and senior government officials, but also chief executive officers, CEOs, and other high executives of corporations. So crime, what we call crimes against peace, is a generic term used to describe 4 existing crimes that are deemed to be so offensive that they have been identified an international crime against peace. They are considered the worst of all crimes, and during wartime, actually, any severe damage to the natural environment is considered as a crime, but at certain conditions. For example, if the size exceeds 200 kilometers in length, if impact on ecosystems exceeds 3 months, and or severely impacts on human and natural resources. However, ecocide is not yet included within the remit of the court. Ecocide, which happens during peacetime. And this, according to a number of lawyers, here we have then a missing crime against peace. Ecocide during peacetime is precisely this missing 5th crime. So during, very interestingly, we have no time to get more in depth in the history of ecocide, but ecocide is not a new proposal. It has actually a history. And during the drafting of the Rome Statute, which is the governing act of the ICC, it was not just 4 international crimes against peace that were on the table. Between the mid-80s and 90s, so during this drafting period of 10-11 years, in fact, there was already a 5th crime, and that was ecocide. So ecocide per se, so environmental harm during peacetime, was included in, was part of the draft. And in that sense, again, ecocide has a previous history. But for political reasons mainly, in 1996, it was simply removed off. And this despite the strong opposition of a number of states. And what were supposed to be the crimes against peace that would protect the well-being of all life had been reduced down to 4 international crimes. A growing number of lawyers then and environmental advocates don't want that crime to disappear again. And they argue that we can put this back in place. In 2010, among other lawyers, but she's a prominent, or she was because sadly enough she passed away a few months ago, but a leading figure of this campaign. So in 2010, Scottish barrister Paul Higgins proposed to amend the Rome Statute, this in order to add ecocide to the list of international crimes at the International Criminal Court. Her point is that at the moment we accept mass damage and destruction of the earth because basically there is no criminal law against it in peacetime. And that is what is known as missing law, she said. Law that is obviously needed but is not there. And where you have missing law, you get injustice. So her main concern was how we take responsibility for how we engage with nature. And the campaign she launched a few years ago has been focusing on how to create a legal duty of care for the earth. So Higgins defined ecocide as the extensive damage to, destruction of, or loss of ecosystems of a given territory to such an extent that peaceful enjoyment by the inhabitants of that territory has been severely diminished. By creating crime of ecocide, no longer, she assumed, no longer will it be lawful to commit daily damage, destruction, or loss of ecosystems of the kind already criminalized during time of war. By placing ecocide on the same legal footing as the international crimes against peace, a superior law which overrides national laws will necessarily create a global level playing field for all. So Higgins' work to make ecocide an international crime sparked the creation of a European Citizens Initiative to petition the European Commission to make ecocide a crime in Europe. So the other campaign, and Ecocide in Europe, evolved into a global grassroots movement called And Ecocide on Earth, as presented a few slides above, with its own proposition for an ecocide amendment. But the focus of both Higgins and Ecocide on Earth's work is not to create a new international court, which would be which would cost a lot of time and resources. Their main concern is rather to find a head of state who is willing to propose an ecocide amendment to the International Criminal Court. Their main idea is that introducing ecocide as a new international crime would elevate the gravity of the crime to such a level that it would create a global duty of care to prevent, prohibit, and preempt ecocide. According to Higgins, this proposal, far from being radical, it sounds a bit But according to her, this proposal is part of an evolution of the law dealing with the impact of contemporary environmental damages. So concretely, what is the process of amendment to amend this Rome Statute governing the ICC? Polly Higgins argued that all the Rome Statute needs is simply an amendment to introduce ecocide as the fifth crime under the jurisdiction of this criminal court. The proposal is procedurally feasible, but as you can imagine, gathering political support is a more challenging task. Technically, any state party, however small, may propose an amendment to the Rome Statute. Then the majority of states parties will need to agree to take up the proposal, and if so, finally an adoption will require a consensus of a 2/3 majority of the state parties, means 82 heads of state. Interestingly, small island developing states, mainly islands of the Caribbean Sea and the Atlantic, Indian and Pacific Oceans, as well as Andean states such as Ecuador, Peru, Bolivia, and Colombia, who are some of the most affected by environmental concerns, seem the most likely candidates to move the amendment forward. Yet, if these countries take this initiative of proposing an ecocide amendment at the International Criminal Court, they will then need to get enough other heads of state on board in order to reach a 2/3 majority. So again, as you can imagine, gathering state support might be a difficult task. But in the absence of ecocide, what do we have? So currently, soft law, as it is called, and civil law, corporate law, and environmental law, these first and two tiers don't prohibit ecocide. Soft law, such as, for example, the Paris Agreement, you have certainly heard about, the Sustainable Development Goals, SDGs, or a UN Global Compact, all these instruments are based on good faith, and they basically offer no recourse in a case of gross environmental damage. The second tier of governance provides only limited remedy for ecosystems destruction. We have civil law here, but we have also environmental law, corporate law, for example, so different branches of the legal field. And they provide only limited remedy for ecosystem destruction, primarily by fines, means financial compensations. Remedy for climate change is even weaker, knowing that we have no remedy in place. In this configuration, first and second tier, the burden is on the individual to sue, and business, of course, big corporations, to start with, can and in fact do remain operating the way they were. Where there is a court declaration recognizing state obligations, as we have seen with the Urgenda case in the Netherlands, enforcement remains limited. So the top tier is the tier of justice, and by legally defining ecocide as an international criminal offense, a legal duty of care is then created. At that level, the state is obligated under criminal law to prosecute alleged offenders. Individuals are held to account in a criminal court of law, either at the national level or at the international level, for example, as it could be under the jurisdiction of the International Criminal Court. And without a crime of ecocide, there is obviously a justice deficit. We are back to those limitations of the first two tiers. There is a justice deficit and society remains unprotected. So more concretely, establishing a crime of ecocide should ensure that persons of superior responsibility, means not only heads of state and senior government officials, but also chief executive officers, become individually criminally responsible for serious damage which they recklessly cause or contribute to. Here the argument is that those who wield significant power, either governments or corporations, are particularly responsible, as they are better placed to make a difference if they change their behavior. So proposed ecocide should be prosecuted regardless of the intent of the perpetrator. It is here the seriousness of the harm that ultimately counts, not the intent of the perpetrators. The challenge is to criminalize those individuals, corporations, industries, and governments that, even in the light of overwhelming scientific evidence regarding, for example, climate change or biodiversity loss, continue to contribute to the problem through acts or omissions. A law of ecocide aims precisely at stopping the flow of environmental loss, damage, and destruction at source. It is designed to go upstream to the source of the problem, maybe contrary to existing environmental laws. For the alleged crime of climate ecocide, the prime suspects are the leaders and leadership structures of the largest fossil fuel companies in the world, the so-called carbon majors. We know now, based on recent research, that 100 active fossil fuels producers are linked to 71% of global industrial greenhouse gases since 1988. 1988 is the year in which human-induced climate change was officially recognized at the international level through the establishment of what we call the Intergovernmental Panel on Climate Change, the IPCC, which was completely unknown a few years ago, but which became more famous recently. We also know that almost a third of historic emissions come from publicly listed investor-owned companies, more than half from state-owned companies, and a bit less than 10% from private investment. So prohibiting ecocide and creating a law that makes it mandatory for carbon major states and carbon major corporations to end ecological ecocide and significantly abate climate ecocide has the potential to be a game changer on a global scale. Companies concretely will require a period of transition whereby no prosecutions are pursued while they change their practices from polluters pays, which is a principle recognized in international law, the principle of polluters pays. They switch from this principle to another principle consisting in saying that polluter does not pollute anymore. So this is the idea. So we have talked about criminal justice, crimes, courts, and so it is a bit scaring. But actually, these processes and the idea of making ecocide a crime relies heavily on what we call restorative justice. Restorative justice is an option for defendants. It is offered as an alternative to sentencing options. According to this scheme, parties can attend a restorative justice hearing to come to some form of agreement with parties that have been adversely affected by the ecocide. So parties agreed to meet with each other and with representatives of the parties who have harmed to engage in a process where all parties can speak. The aim of the process is to transform and restore. It is solution-based and non-blame driven. Through such process, companies, banks, and governments can accept responsibility for restoring territories adversely impacted. And restorative justice is already used, so it's not a complete utopia. Restorative justice is actually already used within the criminal justice process in many countries. And then it could be just expanding its remit to include individuals who are in the position of superior responsibility, and expanding this remit has the potential to resolve seemingly standstill disputes. So to sum up, when we criminalize environmental mass destruction, a legal framework is established within which to seek justice and remedy. It means not financial compensations, but instead the options of imprisonment and or restorative justice. So now back to the classroom. What are we doing with all these trends, ideas, critical discourses, and proposals? All my classes basically at Comaba address the relationship between law and the environment. So in the classroom, we focus more particularly on the recent development of critical approaches to environmental law and governance. We try to get more familiar with the range of ongoing discussions dealing with global environmental challenges. In some classes in particular, we explore how courts and tribunals deal with climate change, biodiversity loss, and extensive environmental damages, knowing that the main issue discussed is how these courts, how these tribunals contribute to the development of new approaches and even innovative regulations. For example, we explore the rapid development of climate change litigation, as briefly exposed in the beginning of this presentation. Regarding climate change litigation, we do not focus on legal technicalities. Instead, we discuss a wider range of issues, such as the increasing role of scientific experts in the courtroom, the growing importance of human rights approaches to deal with climate change impacts and biodiversity loss, and so forth. We also explore what is happening outside the traditional courtrooms. For example, we have now a number of new projects conducted by legal scholars and practicing lawyers, and we have also the emergence of new platforms. Regarding the development of new projects, for example, we have this so-called Wide Law Judgments project, which was launched a few years ago at the initiative of a group of Australian legal scholars and practicing lawyers. And this project basically consists for its contributors in selecting existing judgments, so decisions which have been taken already by courts and tribunals, but they're not satisfied with the decisions as they have been adopted, and then they decide as practicing lawyers and legal scholars to rewrite these judgments based on a wider range of arguments, including, of course, critical arguments. In so doing, they remain lawyers, they remain practicing lawyers or legal scholars, but they just try to reflect more critically on existing decisions. So in the classroom, we have on hand a number of these decisions, and we try to reflect on these critical arguments. But in the classroom, we also engage with what we call mock trials. We also engage with these mock trials, means trials involving real lawyers, dealing with a real-world situation, but not exclusively based on existing laws. Such trials are generally organized to propose a legal reform, to road test a legal proposal, or to expand the discussion beyond the limits of existing and often quite narrow legal frameworks. And we engage then in the discussion actively through role-play simulations. If you have any questions, then I can answer it a bit after. In 2011, a mock Ecocide trial was actually held in the Supreme Court of England and Wales. During this trial, 2 fictional chief executive officers were put on trial for causing ecocide. The Athabasca tar sands, Canadian oil sands in northern Alberta. This is a real case. The trial was based on true events and publicly available documents. It was not scripted. The jury was vetted, and the legal teams included some of the key figures, practicing lawyers in the UK legal field. So a draft ecocide was applied to mirror the international crime of ecocide as if it had already been implemented. In addition, restorative justice provisions were included, and this was, interestingly, the first time that a law yet to be put in place was road tested by real lawyers with real arguments regarding a real situation. So the court process allowed for the draft law to be applied and examined from a number of angles to establish whether or not it was viable to prosecute such a crime at the national level. And then in the classroom, again, we engage in this discussion. We examine the range of arguments without entering, of course, in legal technicalities, but we examine the range of critical arguments and the way they have been developed through these mock trials. And finally, a last example, we also examine the development, the emergence of new platforms. For example, the so-called Rights of Nature International Tribunal, which also helps advance proposed amendment to the Rome Statute to recognize the crime of ecocide. This tribunal is a citizen-created initiative that relies on the mandate granted to it through the Universal Declaration of the Rights of Mother Earth. It gives people from all around the world the opportunity to testify publicly as to the destruction of the Earth. The tribunal features internationally renowned lawyers and leaders for planetary justice who hear cases addressing issues of massive environmental loss, damage, and destruction. And interestingly, it offers judgments and recommendations for the Earth's protection and restoration. So, for example, we have two cases, and I will mention just the last one. Texaco-Chevron, actions in Ecuador, during which two lawyers from the Union for Victims of Texaco gave evidence of how the actions of this corporation had led to the spilling of millions of gallons crude oil and the dumping of billions of gallons of toxic wastewater and hazardous waste, which had left devastating effects on the Amazon jungle. So it is a platform, and actually it can inspire a legislator, and it necessarily contribute to a kind of dynamic regarding the possible development of new environmental regulations. So just to conclude, I was having a coffee before coming, and in the coffee shop there was some music, famous song saying still 1,000 things to say. I still have 1,000 things to say, but time is limited. And I would like then to conclude on these words by Polly Higgins, who again, sadly enough, passed away a few months ago. And her words are the following one. One thing is certain, we are living in an era of transition on a scale that is unprecedented, the full extent of which we shall not comprehend until we look back in time and say, this was the beginning of the end of the era of ecocide. Thank you very much for your attention, and then we have still a few minutes to discuss it. Thank you very much.